Hello, I'm Jim McNall, iCrimp Risk Management Specialist. And so today, Tammy Middleton, our new iCrimp HR Risk Manager, and I are going to talk about, the title says, personnel issues for small cities. The reality is that the personnel issues for small cities and large cities are about the same. It's just that small cities have less resources sometimes. So we'll talk about some of the challenges and some of the things to keep in mind. When we see challenges from a variety of ways, oftentimes it kind of starts with not understanding what our lane is and not staying in our lane. So understanding roles and responsibilities is really an important function. So cities, unlike all other local units of government, have an elected executive, with the exception of the 3 city manager cities where they have an appointed executive. But for most cities, the mayor is the chief executive officer. So that means that the mayor supervises city employees in general, presides over council meetings, but is not a member of the council, and that's sometimes really important. Can call special council meetings, require a variety of other things. Carries out the police powers established by ordinance or state law. And again, police powers don't mean going out and arrest someone. It's primarily about health and welfare. It's making sure the garbage is picked up and the sewers work. It's those probably less powerful positions that we don't always think about, but things that need to be done. Generally, mayors can break tie votes and they get to veto ordinances. That happens very often because the reality is most of the time ordinances aren't the big issues that cities deal with. As an executive, the mayor directs employees, maybe with the help of department heads, other supervisors, determines priorities, again, subject to the council policies and their budget, coordinates administrative functions with other department heads and especially with the appointed officials that have a responsibility to the city, and then makes personnel decisions with generally by himself with the department heads, with the 2 exceptions, and that is the appointed positions, which is the clerk, treasurer, attorney, and others as determined by the council. That's a shared authority, so the council must approve those positions before they're official for the city. And then for cities that have public libraries or city libraries, that's a really special case that's set up a lot different than anything else. So library employees do not fall under the jurisdiction of the mayor. The mayor recommends and the council approves the trustees, and then the director and any library employees actually work for the trustees. So that's an exception. It's the only statutory exception that I'm aware of for cities. Other public agencies, especially counties, have a variety of those. But if you have a library, just make sure that you're looking at those statutes because they are a lot different. Those are city employees, but not under the guidance of the mayor. So the council does have a role, even though they're not the day-to-day supervisors. They pass the laws, they pass the policies, approving the budget, and by definition, the property tax levy, and approve payments of city bills. And that's a really important role. That should include those things that are like payroll, benefits, all those costs should also be in those list of bills, even though they may be paid before the council meets. So the council also has a role in personnel management, adopting a personnel policy and keeping it updated. So most cities probably have a personnel policy. It may be worth checking to see when's the last time it was updated because some of the rules change. And so other policies that the council should adopt are vehicle uses. Who needs a vehicle use policy? Only those cities that have a vehicle, or those cities that don't have a vehicle and have employees and elected officials and others who use their own vehicles for the city purposes. Purchasing. Who gets to decide on purchases? What's the limit of their powers to purchase without going to either to the mayor or ultimately to the council? If you have electronic gadgets, computer policies, you need to make sure that those are up to date, including things like use of city email, social media, and to a certain extent even providing guidance on personal use of those or the use of personal devices for city uses. We talked about that in the other class a little bit, but because city elected officials, employees, even volunteers are all public officials, what you create related to your job is most likely going to be a public record, and so it's important to make sure that employees and everyone understands that. The policy adopts the budget, and then the council has a role because the citizens in your community expect that if they go to a council member with a problem, that will be dealt with, especially if that deals with concerns about employee performance or behavior. The appropriate thing for any council member who has an issue brought to them is to take it to the supervisor or to the mayor. The council is not the person who is a direct supervisor and needs to be careful about getting involved. So the council, again, has important roles, but the power of the council to take action on behalf of the city is limited to when the council is in a meeting with proper notice and agendas and acting as a single body. The only real power that an individual council member has is to create liability for the city. So no individual council member should ever take it upon themselves to supervise, discipline, or fire, especially the latter, any employee. We've had that happen. What that means is that those council members acted with apparent authority but without real authority, and that can create some serious liability for the city and therefore for ICRIMP, which is why we care. We've been talking about general employees. Each city by statute has 3 appointed officers, and again, the difference with the appointed officers is that they are recommended by the mayor, appointed, and must be confirmed by a majority of the full council. So that includes the clerk, treasurer, attorney, and any other officers who are determined by the city. And it's important that that be done by official action. So there should be a list. So we often see chiefs of police, fire chiefs, public works supervisors, city administrators, where cities have those, that are also designated as appointed officials. It's important that you have a list of those. It's not uncommon for us to get a call from a city saying, we have an employee issue, and we say, well, is this a regular employee or an appointed person? Well, we're not sure because we don't have a list, but 3 years ago, the council confirmed their hiring. Well, does that mean that they're appointed? Not necessarily. It's important that you have a clear list so that you know which positions are appointed and which ones are regular employees. Again, the process is different. The mayor appoints someone, but it must have a majority of the full council. So if you have, that means 3 council members, if you have a 4-member council, or 4 if you have a 6-member council. And it's one of those places where the mayor does not get to break a tie, and because the statute says must have a majority of the full council. Similarly, removal of appointed officers is done by the recommendation of the mayor. Says, I'd like this person to have their appointment removed, and it must be confirmed by a majority of the full council. Or, and I don't ever recall hearing about this being done, but an appointed official can be removed by a unanimous vote of the full council. And full council means 4 or 6 or 5 or 7, depending on the city. But it must have everyone there. So if you have a vacancy or you have someone who is absent at that meeting, then you cannot remove them using that process. So what does appointment really mean? What it means is, and the reason that the process is set out in statute is, the appointed officials owe their allegiance to the city as a whole rather than to the mayor. And that can be important because if the mayor's, out doing something that they shouldn't do, it may be the duty of some of the appointed officials, the city attorney or sometimes the city clerk, to bring that to the attention of the council or to others. That's really awkward if the mayor is your boss and can fire you, whereas For appointed officials, the mayor doesn't have that independent authority. So it's always important to remember that the city attorney especially owes their allegiance to the city as a whole. In fact, I sometimes have had questions, well, does the city attorney represent the mayor or the council? The answer is all the above. Most of the time, the duty of the attorney is to just say, here's what the statute requires, here's what the law says. Within that, you can make determinations as you wish. Very seldom is that going to create a conflict by just stating what the law requires. But there are times when that's a real challenge. Then the city attorney may need to say, you know, I can't do both. We may need to get an additional attorney to help with this, sort out this conflict. Updating the personnel policy is really important. It's a role of the council ultimately to approve a personnel policy. It's important that all supervisors, and that includes the mayor, know that you have a policy, knows what's in your policy, and follows your policy. Especially immediately following elections, we'll often see elected officials who say, well, you know, this policy was here when I got elected. I don't really like it, so I'm just going to ignore it. That can be very, very costly. If you're in a position of authority, you have the ability to change it or to recommend changes, but don't ignore your personnel policy. That'll get everyone in a lot of trouble. So if you're updating your policy, there's a variety of things that are important to consider. Is your policy going to be an at-will policy or for cause? And the reality is you can have either. It's a choice for the city. Our sample policy on the ICRIMP website is now an at-will policy. One of the things we recommend is looking to make sure that you don't have a hybrid. I can't tell you how many times I've looked at personnel policies that says at the beginning, we're an at-will employer. All employees are at will. And then later on in the discipline section, it says employees will only be terminated for cause and they have an opportunity for a hearing. Well, which is it? It can't be both because those conflict with each other. So make sure that you do not have a hybrid. Now, if you have an at-will policy, that doesn't mean that you can't treat employees fairly. You can't give them an opportunity to talk to their supervisor, to the mayor. Yeah, so our recommendation is promise less, give more. Never fire someone without giving them a reason. Even though your policy may say at will, if you fire somebody without giving them a reason, there will be a reason and their attorney gets to make it up and it will be an unlawful reason. So we always recommend give reasons, but don't promise that. Recognize that in your personnel policy you need to refer to the process in statute to appoint the appointed officials and that they are not subject to certain other elements in your policy. This is sort of an aside, but one of the things that we have had some challenges with at the ICRIMP program is who gets access to personnel files. My recommendation is to look at the sample ICRIMP policy that's on our website, a sample specifically for cities, and in there it says that the people who have access to personnel files of employees, and this is the general file, the one that has evaluations, applications, those sorts of things, not necessarily the medical file, which is very, very limited. But anyway, that general file, the language that we have adopted in the sample policy on our website is supervisors, which include the direct supervisor, maybe the department head if that's different, and the mayor can look at personnel files at any point. The council has access only to personnel files when they're acting in the course of official business in a meeting. That's going to be rare. What does that mean? That means that if an individual council member comes into the city clerk or the HR director and says, I'd like to see Joe's file, the answer is you don't have the access to do that. If the council as a whole needs to do that, they can go into executive session and look at that. Generally, that should happen only when you have claims or litigation that you're involved in. Harassment, another issue that's really important. Make sure you have a clear harassment policy, give short definitions of what's prohibited, what's unlawful harassment, and who you report to, and provide a variety of options for it to report. Another section in your policy that we recommend that you follow our guidance on, look at our sample policy, is in the past we'd often see personnel policies that said any employee, if they're going to resign, they must do so in writing. And the challenge with that is, I can't tell you how many times we've had employees who on Friday afternoon, they get fed up, they run out the door, said, I'm out of here, I quit, you'll never see me again, slam the door. Maybe you use a few choice words as they're going out the door, and you're thinking, oh good, I'm so glad to see them go. And then Monday morning, they come back to work with their tail between their legs saying, oh, you know, I went home and talked with my wife and I didn't really mean it, I'm back. Well, our sample policy provides that if someone resigns orally, you as a supervisor or the city or the mayor can follow up in writing and say, you resigned when you left today, we accept that resignation, please turn in your keys. It can save some pain and suffering by doing that. And again, if you have a library, make sure that that specifies some different rules for the library employees. The statute specifically states that library employees are city employees and follow the city's personnel policy unless the city has designated otherwise. I know the city of Twin Falls, for example, has designated otherwise, where the library has a different personnel policy. They do their own personnel issues. But most part, that personnel policy that the city has applies to the library as well. What doesn't apply is the process by which they are supervised. So it's important to recognize in there, it says if you're a library employee, this policy applies to you, but you are subject to the supervision of the library director, and if you're the director, to the supervision of the library trustees. So, updating a personnel policy is never fun and easy. There are some resources. My recommendation is, first of all, look at the ICRIMP website for our sample policy, specifically for cities. Utilize the services of your city attorney, human resources, if you have those, and if you don't, you may even want to borrow some. Talk to some of your neighbors, get some help from others. Involve your management staff, involve especially your department heads in the process of updating your policy, because ultimately, oftentimes they're the ones that have to deal with it. They may have some good input. And recognize that public employment is different. So we recommend to, you can go online and say, here's a sample personnel policy, scratch off the sample and put your name in and you have a personnel policy. Well, if it's just an off-the-shelf one, it probably doesn't recognize a lot of those special situations that apply to public employees. So, update your personnel policy, review it, make sure that it's current. Use our sample policy, use the resources you have, and if you have questions, reach out to us at ICRIMP. So thank you for listening. I'm going to turn it over to Tammy to talk about some more issues.
Hi, I'm Tammy Middleton. Thank you for having me. I'm going to start with employee posters that you need to have posted somewhere in your organization. These posters should be areas that are commonly used, like break room is usually a great spot, time clocks if you use them, great place to put up these posters for your employees. I'm not going to go over them in detail, just wanted to provide you with a list to make sure that you're aware of the posters that you need. The Family First Coronavirus specific posters are available on our website if you have not got that one posted yet. And you may also have a workers' comp poster that you want to add that should be provided by State Fund if you use them, or if you're self-insured, you can get a form for that one as well. So I want to talk to you a little bit today about personnel files and what you need to have and where they should be stored. So first and foremost, your I-9 should be in a completely separate file and stored in a different location outside of the employee file. Typically, people can just put them in a binder. Alphabetically is fine, but however you store them is fine as long as they're not in the employee file. And they should be in a secured location because they contain personal identifiable information such as social security numbers, addresses, birth dates, that sort of thing. And then there's your regular personnel files. They should be in a locked and secure location. So at the very least, they should be in a locking file that is not accessible by anybody from the office or from the public. File cabinet is fine. I prefer a double lock system, so if they're in an office, the cabinet can be locked, but also the office can be locked as well. But at least one lock is best. And then these should contain things like your employee file should have applications, evaluations, the employee's resume if they provided one, any kudos, way to go, those sorts of things that you may want to remember later on if you're doing an employee review, and then corrective actions, of course. If you have medical files for your employees, those should be stored separately. Medical files should contain information like requests for FMLA, ADA. If you require your employees to provide you with doctor's notes when they're out sick, those should be kept in a separate medical file. Anything that has to do with the employee's health should be in a protected and separate file. If you have specific training for your organization or for certain staff, you should have a training file. You can keep training documents in the employee file, but I find that it's very difficult at times to be able to produce training records if you have to go through every single employee's file to pull out that documentation. So it's good to have at least a list of who's attended training and when they have training. Also, that's good for certifications if you have certain types of certifications that your employees need to maintain. Just having that separate record so you know when those expire, when they need to recertify, et cetera, will be very helpful. And then your payroll information, which is usually kept by your payroll department, they should also contain information like garnishments, any of those legal things you can keep in a separate file, and they're usually held with payroll. I want to go over briefly what you need to document when you're documenting events or interactions with your employees. So always want to record training, even if it's just a simple ethics training or maybe harassment training or how to do the job sorts of training. Just make sure you include the topic, the date, who attends your training, and who your trainer is if you need to reference that in the future. You want to make sure that you document conversations with your employees, whether those conversations are regarding how well they're doing or if they have some skills needs that you want to address or if they have some behavioral issues that you want to address. Make sure that you document it, even if you're not writing them up formally. This will help us show a trend of behavior for the employee if we need to use that for future corrective action. So make sure you include the topic, the date of the conversation, who was involved in that conversation. Your employee does not need to sign it, you just need to keep them in the file. You do obviously want to keep corrective action in your employee files. When you document corrective action, make sure you record the specific situation that resulted in the corrective action, your expectations of the employee going forward, any agreements you make with the employee. So for example, if they are lacking a skill and you would like them to learn Excel, then you want to document that's your agreement, that you're going to provide them training or a class or a coworker to help them out. Anything that you agree to for corrective action needs to be documented. And then always a timeline. It's important for the employee to know when you expect the behavior to be corrected or when you expect the skill to be acquired. And that can be immediate. You can write in their documentation, I expect you to immediately stop doing that behavior or immediately start doing that behavior. Just make sure that it's documented so everybody's on the same page. And then employee performance. Always want to include employee performance reviews. Make sure that all the performance reviews are accurate and fair. So just making sure that we avoid any type of bias when doing performance reviews. And it can sometimes be helpful just to go back and refer to those notes from conversations you've had in the past and use those to build your employee reviews. So how to document? It's really critical that we document employee interactions in a timely manner. It will be difficult, if not impossible, to remember who attended your training in the past. So just make sure that that's written down. If you have a level-setting conversation with your employee about a behavior or a skill, it may seem very obvious right now, but 6 months down the road or at that point when we're in litigation, it may be very difficult to remember exactly what was said, when you said it. And if you make the mistake of putting down the date because you've written it down later on instead of when it happened, and you put down a date, for example, when that employee was actually out of the office on PTO or something, that will bring into question all of your documentation. So it's really critical to just make a few notes right when you have those conversations. Make sure you include details that later people forget, which include who was involved, who witnesses were, maybe who the victim was, especially if you have a bunch of employees with the same name, which frequently happens, and make sure you include the date and time. Make sure you don't paper the file. So this could be a couple of things, where after the fact we're trying to recreate documentation we should have been doing all along and put it in the file because now we're in litigation, or if you have an employee that you particularly do not care for because of their behavior or their attitude, or you just have a conflict with them, and so they have a whole file this thick full of information about every little thing they've done wrong where every other employee does not have that. That too can become a problem. So just make sure that whatever you're doing with your employees, you're consistent. So if you're having a weekly conversation, you have that for everybody. If you're writing up employees for behaviors or tracking conversations, make sure you do that for all your employees. How to document corrective action is very important. When we go back, and sometimes we have to go back a year or two, and sometimes longer, especially in the cases of litigation. And so we want to make sure that all the information around that event is contained in your documentation. So when you document corrective action, make sure you describe the situation. Be specific. Just say exactly what happened and how it happened. If an employee used a bad word, make sure you write down exactly the word that was used as opposed to saying they cussed. At some point, what you consider bad and I consider bad may be different. So let's be very specific about that. Describe your actions. So if you retrained the employee on what they needed to do, or you reviewed with them a report that needed to be turned in, make sure you just write down what you did and that how you are helping the employee to understand and do their job better. Make sure you stick to the facts. Avoid opinions. Avoid negative word choices. I want to make sure that nothing in your documentation sounds like you don't like the employee and you may be targeting them. Those are the types of things that get us into trouble later on. Include the date of any previous corrective action. So if this is now the time where you're putting an employee on a written warning or written corrective action because you've had 4 previous conversations, we want to make sure and have the dates and topics of those conversations so that we can demonstrate a pattern of behavior with the employee. But we also want to be able to demonstrate that you have given the employee a reasonable amount of chances, that you have set a fair expectation on what they need to do, and that this is the next logical step. And then make sure you state the impact of the behavior on others or the organization. So if an employee has poor conduct with the public, you make sure that you state that in their corrective action, that this had a negative impact on the public, or that this caused you to have to field a complaint from somebody in the public, or other employees felt intimidated by the employee's behavior. Those types of things are important for us to understand the setting in which the action or behavior occurred that we need to correct. So training is the key to success. So make sure that we have training for the mayor and council on roles and procedures around their meetings, how to conduct them, when they should be, those sorts of things, and how to include employee information in those types of events. Make sure you're training supervisors on how to supervise. A lot of times we have employees who are promoted into the position because they have a great deal of job knowledge, but that doesn't necessarily translate to great leadership or knowing how to supervise employees. So make sure that we're providing those types of trainings for them. Train everyone in your organization on harassment, ethics, and discrimination and policy expectations. Make sure you document your training so that we can go back and look and see that these types of trainings are occurred and everybody knows what's expected of them. Safety training is also very important, even for your office staff. Just make sure that everybody knows what is safe, what is expected. It can be as simple as cord management or ladder training, just making sure that everybody knows what's expected. And then, of course, all the way up to advanced safety training for people who work in hazardous jobs or with large equipment, things like that. Avoid liability. So before you terminate an employee, just make sure that the person terminating the employee is authorized to make that decision. It may seem obvious if you're the person they directly report to, but maybe you don't have that authority. Make sure you understand your policy and you know. Check and follow your personnel policy. What are the steps to employee termination? consult with your HR team, your city attorney, and certainly iCrimp is available too, to help you walk through the process that now that you've made the decision to terminate, let's make sure that all the ducks are in a row and that we don't have anything pending that may create a litigation risk for us. And of course, all litigation risk cannot be dismissed or removed from a termination action, but we are definitely here to help you and make sure that we give you the best chance possible. Here's our contact information. If there's any questions that we can answer for you or help you out, or if you just need someone to be a sounding board for an employee action that you're thinking about taking, we're always here to help. Thank you.